Testing, 1, 2.
Testing.
Welcome to CES.
All right, we're good to
Oh,
go.
yeah.
Hell yeah.
All right, good morning, everybody. Welcome to CES Day 3. How's everybody's show going? That's good. Awesome. Good to hear. Welcome to today's panel, AI and Fair Use Showdown, Who Owns the Future of Innovation? I am Michael Petricone, and it is my privilege to moderate this critical discussion here at CES, where the intersections of technology, innovation, and policy all take center stage. Now, as you know, having walked the show floor, AI is reshaping our world at an unprecedented pace, revolutionizing industries, enhancing productivity, and unlocking new creative possibilities. However, alongside these advancements, AI's reliance on vast databases, often sourced from copyrighted materials, has sparked profound debates about the boundaries of fair use and the rights of creators and the ethical implications of innovation. At stake is not only the livelihood of countless creators, but also the principles of fairness and the competitive edge of the United States in the global tech economy. So today, we are very lucky because to help us unpack these complex and timely issues, we are fortunate to have three amazing panelists. To my immediate right is Cameron Trimble. He's the managing partner of HUED Strategies, an integrated communications firm based in Washington, D.C., with 18 years of experience leading communications and digital engagement strategies for Fortune 100 companies, the White House, the U.S. Congress, and political campaigns. And from 2021 to 2022, he served as President Biden's White House Director of Digital Engagement. Next, we have Jess Myers, visiting assistant professor of law at the University of Akron, and a noted expert in intermediary liability and content moderation. And Jess's work provides critical insights into how legal doctrines like fair use adapt to emerging technologies like AI. And then finally, we have Chris Lewis. He is the president and CEO of Public Knowledge, a leading advocate for open internet policies and balanced copyright systems. Chris is a legend in DC. He brings a wealth of experience in shaping policy frameworks that ensure innovation thrives while respecting creators' rights. So just to set the table here, it is really hard to overstate the importance of this debate. If you're a creator, for creators, this is about protecting the integrity of your work and ensuring fair compensation. For innovators, this is about preserving the freedom to experiment and build transformative technologies. And then for consumers and users, it's about ensuring access to cutting-edge tools and content in a way that respects ethical and legal boundaries. And for the United States, for us as a nation, striking the right balance between all these competing interests is critical to maintaining our leadership in the global innovation economy. So we are thrilled to have such a knowledgeable and diverse panel to guide us through these actions, or these issues. And as we begin and as we talk, I just encourage everyone to consider the broader contours and the broader implications of this debate. How can we foster an environment where creativity and innovation thrive together? And what role do legal, ethical, and collaborative frameworks play in shaping the future of AI? So with that, let's get started. What I would like to do is just ask each panelist to talk about themselves. Why are you here, and what is your stake in this debate? Starting with Cameron.
Thank you so much, Michael, and thank you for everybody attending here. Cameron Trimble, managing partner at HUED Strategies. I think I'm here as serving as the digital engagement director for the Biden-Harris White House, as well as in the 2020 campaign I ran his paid media program. So all of the $100+ million spent on advertising and targeting. And I think while I'm here and a lot of the work that we've been doing, implementing on the campaign and political side, is the use of AI to basically 10x, I would say 20x our ability to produce content, but also in terms of advanced targeting to really hyperserve and super serve people with content that will emotionally affect them, move them to make a choice. We don't live, our company doesn't just live in politics. I think most of my work is on the political side for our company, but we also do this for consumer-based companies and large organizations. But now, as a former creator myself, I used to shoot videos and movies and photos and so forth. I think the complex nature of what artificial intelligence is now and is moving into, not only just pushing creators out, or we're working alongside creators, but given that these large language models and large use models are taking information, copyrighted information from creators to then build their own, to then build net new content, who owns it, who's able to use it, and then what is our responsibility on the policy side, even as a company ourselves, what is our responsibility to tell the end consumer that this was something that was generated through AI. So there's a lot of issues. It was kind of the wild west this year in the election year with the use of AI. Those laws really haven't caught up, but excited to have this conversation.
Hey everyone, thank you so much for being here. Thank you for putting this panel together, and huge thank you to CES as well. I'm Jess Myers. I'm a law professor at the University of Akron School of Law. What is my stake in this? I'm a technology enthusiast. I'm not only a technology lawyer, I'm also a computer scientist. So technology has been in my blood, literally ever since I was the age of 4 when I got to experience the internet for the first time. I'm really excited about generative AI specifically. I'm excited about AI. I know we're going to talk about later some of the important innovative potentials of this technology, so I'll save that for when we get to that question. But I will say, one specific use case that I'm really excited about is the way that generative AI is shaping education. This was my first semester teaching at Akron Law, first semester teaching first years. And the stuff that I saw them doing, I completely permitted AI, generative AI in the classroom, something that, might, for some educators in the room and even for my colleagues, may be a little bit uncomfortable, but just seeing the way that they were using these tools to sort of revolutionize legal education. I had one student who was using AI to take her notes and put them into a podcast, for example. So I'm really, really excited about the technology. I worked for Chamber of Progress previously, which partnered with many of the technology companies that you all are familiar with, including AI companies like Midjourney. Before that, I worked for Google, learned a ton about the inner workings of that company and sort of, why content moderation and why protecting, defending the internet is so important. And then before that, Twitter. So again, I'm a tech enthusiast. I love AI, and I'm really excited to talk about it.
My name is Chris Lewis. I'm President and CEO of Public Knowledge. Thank you for having me here, Michael. And I've had a career in government and in civil society nonprofits, all about how do you make sure that our laws and society benefit the public for justice, for equity, and so in really plain language, so that we can have nice things. That's why I love tech policy, because Public Knowledge, we're working to fight for an open internet, free expression online, affordable access to creative tools, and communications tools and creative works, and that we believe that when you put those public interest values and apply them to new technology and innovation, that over the last couple decades, 3 decades, we've seen that that open technology, by and large, creates greater equity and greater opportunity. We've seen the internet and new innovations like AI create opportunity for knowledge and information to be shared more widely, for more voices, diverse voices to be heard, and that requires continuing to make sure that the laws applied, especially copyright law and fair use, in a way that maintains that balance so that we can, yes, have nice things. There are real challenges and harms that come with new technologies and innovation. We don't ignore them, but you also need to make sure that you balance it out with protections that ensure open access to knowledge and information as a public interest value.
Okay, so we're going to talk about fair use and how it applies to AI. But before we dive into that, let's just set the stage and just talk about how this works from a creator's point of view. So Cameron, when you were talking about AI, you talked about how it enables you to kind of 10x your creative powers. Just unpack that a little bit. What's the relationship between creativity and AI, and how do you use AI to advance your work as a creator?
We're still at the stage where I would say it's in partnership or augmented. AI is augmenting our creators, so it's still creator first. One of the pieces of our business is creating advertisements, whether that's static ads, digital ads, video, and so forth. And now there are a ton of different generative AI platforms and services you're able to use that essentially it's like giving one of my senior producers extra tool brushes, extra paint brushes to be able to take that and say like, hey, I don't have time to fully animate, but I can animate something or animate a concept. Also, now we're also using AI models to crunch the vast amount of data that is out there to better target and service, whether it's ads and content or understanding public sentiment. Now there are so many different data sets you can pull from social, from transactional data, voting data, depending on so many different things to try to get into the mind and say like, what are you, sir? What is really going to affect you? There's no way that a person can kind of read all that data sets, and so being able to use artificial intelligence software to be able to better target and also better test content, right, I think is at a push of a button something that just took longer, right, or took more people. I think now it is really finding it. The hardest thing this year was finding people who knew how to use these platforms and softwares because they're only a year, 2, 3 years old. Publication, we're not a huge company, so we don't have the big contracts with these. So it's trying to find people who can pair AI as almost like a partner and an extra, and like I said, extra tools in their toolkit.
Right. Okay. So that's the creator's perspective. So let's now move to the legal structure that makes this possible. Jess, could you explain to us the concept of fair use and what it means and how traditional fair use principles apply to AI-generated content, especially when the AI systems are trained on copyrighted materials?
Do we have 10 hours? This is such a fun topic, and it's also really daunting because I need to explain AI, which for the technologists in the room, honestly, any technologists, lawyers, all of you in here, understand the gravity of that. And then I have to explain fair use, which in itself is kind of a nightmare. I think it's really important before I even go into fair use to talk about generative AI. Let's set the stage, right? So I imagine many of you in here are familiar with GPTs. I'm going to start there. By the way, I teach a 3-unit semester-long class on this, so I'm going to be condensing and glossing over a lot of things very quickly, so bear with me. GPT, so generative, pre-trained transformers, right? Generative meaning that there's an output in response to a prompt, a query. Pre-trained, meaning that we have data that is already used to train the model. That could come from any sorts of data sets. You probably have heard of like the Lion database, for example, but it's pre-trained. And then the last part is the transformer. And the transformer is the really important part here. You can think about it as like literally the brain of the GPT. The transformer is probably the most controversial part of this discussion. And I just want to say as a disclaimer, if we have creators in the room, I know we do, this is a tricky topic, right? Technologists, lawyers, creators, it's a very heated discourse about whether generative AI is stealing their works and taking their jobs. And I think a lot of that discourse comes from the fact that we don't really have a strong fundamental understanding of the technology. How many of you all have heard about the black box theory, for example? Okay, so a couple of you, right? Black box theory is being used. You're going to see it come up a lot, not just with technologists, but we're seeing it come up in the courts as well. We saw a recent opinion out of California where a judge basically said, well, we don't know if it's if anything that an AI does is human expression because it makes its own judgment, and because the black box theory says that we don't know, we don't understand the technology, and therefore we can't make a legal decision about it. What's happening with that black box theory is it's becoming an excuse for not understanding the tech, and so understanding the tech is really important. Back to the transformers. So basically what happens when you are feeding a GPT this data that we talked about, right? It needs a lot of data because the way the transformer works is it is helping the model learn about our world. It's the same way that we read books and we interact with each other and we're learning. The entire point of the GPT is to be able to predict based on what you've given it as an input, be able to predict what the most likely human-like answer is going to be. In order to do that, it needs a ton of data. It needs a ton of data. Now what the transformer does is it takes all of that data, right? That could be images, that could be text, publicly available data, copyrighted works. It takes all of that and it puts it into computer language, right? So we have human language, we understand each other. Computers have computer language. And so that data, the way it's represented in the transformer model is just data, that's it. And usually what happens is after the transformer step, where basically the GPT is learning, you can't backtrack. You can't go into the transformer and say, this person's work, I want to take that out and represent that. Now, some companies might hold on to the data, and they might keep their data sets available in case of auditing purposes and security and other reasons. So that would be one way to see the data. But the important part is that the transformer has not, it's not looking at like a picture of a cat. It's looking at code. It's a technological process for it to learn. Okay, that's the technology part. Let's talk about the law. So fair use is the First Amendment backstop to copyright. Basically with fair use, it says that you can, it's a legal doctrine that says that you have a limited use of copyrighted works for certain purposes. Copyright is a strict liability law. Basically meaning that if you make a copy, the instant that you make a copy or you reproduce somebody's work, you're already in sort of the copyright infringement potential territory. And so that's why when we have a copy already made, which is what's happening when you train a GPT, you have to make a copy in order to feed it to the transformer, we have to then fall back on, okay, well, is that a fair use? Now there's a few factors that the courts consider for fair use. Fair use, by the way, is a very expensive test. Lots of litigation, years of litigation. There are companies that litigated fair use. They were gung-ho on this is fair use, and they litigated it for 7+ years, won and went bankrupt. So this is a very expensive bet. There's 4 factors. The first one is the purpose or character of the use. You might have heard of the transformative test, right? Is the use itself that you're making of the copyrighted work, is it transformative? That's gonna be a big deal for GPTs, because we just talked about how we take copyrighted works and turn it into data. Now, we have cases that say that when you are just using it as part of a technological process, it's fair use. However, you could imagine somebody making a GPT, like the Taylor Swift GPT, where it only trains on Taylor Swift's works, and it produces things that are substantially similar to Taylor Swift's works. That might not be a transformative step. So that's the first issue that the courts have to wrestle with. The second one is the nature of the use. That's not super complicated. Typically, if you're using factual works, fair use. If you're using already published to the public, fair use. Gets kind of tricky when it's creative works. Gets kind of tricky when it's an unpublished work, because a copyright holder has the right to decide when they publish that work to their audiences. So that's the second test. We then look at the market effect, the amount that is taken. How much of the work are you taking? Now we have a case called the Google Books case that also added the heart of the work to that. So you could take a whole work, and that's the entire work. That's probably going to weigh less so with fair use. But then you can also take snippets of works. But if it's the most important part of the work, the stuff that people are really paying for to see, that also could lean against fair use. This factor is important for AI because when you're taking data, you're usually taking the whole work. So that will be something that the courts will consider. And the last one is the market effects test. And this one's really important, especially in recent years. Is your use affecting the market for the copyright holder's work? This question is going to come up when we talk more about licensing. There's going to be an important question about, okay, well, fine. If you're saying that if AI companies start to license works, they decide, look, we'll pay creators, we'll license their data, then creators now have a market for being able to create works that then they can get paid for to have licenses. That could potentially be a market effect. So those are the 4 factors that we're looking at when it comes to AI. You can see the complications here. happy to get into more. I know that was a bit of a lecture, but yeah, it's a very expensive test, lots of litigation involved.
No, that was great. I'm glad we have a law professor on stage. Wait, Chris, do you want to add anything?
That was a great explanation. I'm glad we have a law professor on stage
Sorry it
too.
was so long.
I guess what I would add, Michael, is that when we think about, now that we've had an explanation of how the technology works, I think it's really important to remember why we have fair use, not just how fair use works. That this exception in copyright law is important to promote, yes, the furthering of creative works, because creativity often builds on and is inspired by previous creativity. And it also gets into just what you're able to do as a consumer. Let's go before we had digital anything. We had books, we had music. You would pay for and buy a physical book. You would pay for and buy a recording. You were consuming. You were reading that creative work. Now that we have technology, we have tools that help us do that, and AI is one of those tools. And so we would argue that it's very important that you protect the right to read, protect the right to consume as a consumer information if you legally accessed it by purchasing it, or protect the right to use a tool to do that as well. And AI is a powerful tool for learning and gathering information and then creating something new. And I believe that copyright strikes that balance. If you look at the inputs and the outputs of an AI, the training of models is the learning, it's the reading. And the outputs, if they replicate or redistribute someone's creative work, well, that's copyright infringement. But if they don't, if you create something new, if you create something transformative, that is learning from what you've read and creating something new, and that's something that balance in copyright was written to protect.
Which, by the way, sorry to interject, but fair use is the entire reason why we have generative AI at the moment. So you can think about what's the result. Okay, well, training an AI is copyright infringement. We're done. We're not going to be able to. We aren't going to be able to train these models. So it's in my opinion kind of the lifeblood of this entire industry.
So what you're saying is that, and these issues are being worked through in the courts and so forth, which we'll talk about. But if you were saying that if we end up opting either through judicial or legislative means that training AI on these models is copyright infringement, that basically the AI innovation, like, what happens?
I mean, to be realistic about it, Google will be fine. Sorry, Google. The major companies, OpenAI will be fine.
So,
they're going to license. They have the money. But there's a thriving GPT market right now, where all sorts of people are coding and making these amazing models and services. They don't have Google money, and so do you guys want to litigate for 7 years over a GPT you created for free?
So just to get back to something that you raised, so does the use of copyrighted materials in AI training data sets, does that cause market harm to the original works? Or
It depends.
Okay.
It depends.
Can you unpack that a little bit?
Yeah.
Cameron, you can start.
I look at it as that whenever any transformative technology comes out or something like this comes out, the first wave of people who are just kind of going to get washed over. And as a creator, if it is just raw data, they don't even have, I would say 99.9% of creators, whether it's visual content writers, don't even have the understanding that, hey, my work is now being used, being turned into zeros and ones and being fed into this large model. So I don't even have the recourse to go out and try to, I need to, when the licensing part does come about, and there'll probably be these general licenses, especially on large platforms like a YouTube or places where you actually, I made this piece of content, or I made a book, or I made a video, I made something that I'm gonna then put it on a platform. Usually you're signing away certain rights just by then publishing it on said platform. But there's gonna be such a wave for creators of all types of content that just don't even understand that my content has already been used. So I'm fearful that this first wave of folks, it's already, because we have ChatGPT, so they've already been kind of screwed over. And then this next wave of folks won't really understand how to price, how to be able to do that. I think these larger companies and the platforms you decide to display your work or publish your work are probably going to have those written into their updated terms of service or terms of use.
Well,
Yes, I'm sorry, Chris.
I really want to be careful. I don't believe that artists should be giving up their rights. Artists, if you publish or if you post on YouTube, for example, I haven't read the terms of service, but the artist should be retaining the rights to what they publish on YouTube. And not only that, I mean, YouTube and these other platforms should be paying for helping distribute that content. And that's just a fact. And they are. It's true with publishing houses, it's true with music labels, that's what they do. I think the important distinction is that do you want to protect the ability for the technology to develop that creates this powerful tool for helping people read and gather information? And so you have to draw a distinction between what copyright protects, which is when a work is reproduced or redistributed, versus when someone is consuming or reading it.
Okay, so I have maybe a dumb question, which is, so if you're a reporter and you're interested in writing a story on a topic, like the first thing you may do is read articles and reports and stories by other writers on the topic. And then you educate yourself. And then you reach out to other sources too. You probably do interviews, you talk to people, and, so you gather all the data. And based on all that data that you've gathered, you then create your own unique, specific product.
I'll do you one better.
Right, but
Yeah.
okay, but is that, all right, but I guess the question, you know where I'm going, is this any different from what an LLM is doing to produce the content? How is it different? Which is maybe a dumb question.
I think it's very similar.
Right.
A lot of reporters, how many folks have ever heard of the Wayback Machine? All right, a lot of hands. A lot of reporters value and use the Wayback Machine. It's created by the Internet Archive. They're literally archiving content from the internet for historical records or historical purposes. Right. Reporters go and look at that information and write stories based off of facts that they find in the archive.
Right, without crediting it, of course.
Right, and so they're creating new work based off of their research, and they're using a tool, a digital tool, that facilitates that learning and that new creation.
I'm extremely sympathetic to creators. I have no creative bone in my body whatsoever, and I just want to point out, if I were to use ChatGPT to do a picture of a cat versus somebody who is actually classically trained in art, you're going to get two very different pictures. So just to your point about, is it different, right? The creators that I've talked to are not super sympathetic to that argument because, yes, at the same time, from a baseline level, LLMs, they need to learn from all sorts of data to understand the world. We talked about that. But they do it at such a pace that sort of outpaces the way that we do it. And so that's sort of where I think the creator discussion, or the discourse with creators versus technologists and lawyers kind of come into play is look, you're not only taking my work, but now you're also creating and profiting off of new works as well. So the speed at which we take in the data, that's a little bit different, in my opinion.
So what if you're a creator and you want to opt out, right? How can you as a creator, a news organization or a content creator, protect your content from being used without authorization by companies for training generative models? Are there any legal or technological protective measures you can use?
Yeah, there's a number of ways. First of all, I said earlier, it's important that we're talking about legally accessed content. I mean, people are publicly posting their content online, often without paywalls, and that gets scraped. It's been scraped for decades by social media, and that's been claimed to be a fair use by the courts. That in order to have search, you can scrape information, and then someone asks you a question, you can point them towards a website. But journalists. Others often put paywalls up. It's also part of their business model, is to make money off of people who have been pointed to their website to then have to pay to access the full content, not just the snippet or the hyperlink, which have always been fair use. So, certainly paywalls are a protection. There's been efforts, I don't know that they should definitely be standardized into law, but efforts, if you've heard of robots.txt, where you can opt out. I think that's great. Where people can say, I don't want to be indexed by a search engine, I don't want to be indexed by an AI. Those sorts of opt-out tools are fantastic.
Yeah, it's spot on. It's super fascinating the way in which folks are sort of combating AI scraping, and you're going to see a lot of this develop over time. It's so fascinating because what we're seeing is almost like a cybersecurity approach to AI. Cat and mouse game, right? So, you can do robots.txt, but it's based on the honor system and it's not enforceable, right? You could do a paywall, but as you mentioned, there's ways to get around the paywall, there's ways to scrape around it. Some folks today are poisoning their information and poisoning their data so that when it's scraped, it essentially screws up the transformer and you get a bunch of gibberish. So there's ways to do that, which I think is super fascinating. So keep an eye on the technological developments. I think like the hacker communities are really going to be on the forefront of that. From the legal perspective, it is a mess. It's an absolute mess. I, today, as somebody who has been studying this for so long, I can't tell you if scraping is legal or not. At this point, I can't tell you if it's a violation of the CFAA, California penal codes. It's a mess. So what's recommended for at least, and this is not legal advice, but typical things that you can do, you can send a cease and desist letter. You want to do a lot of things that shows that you do not want them scraping, because if you end up having to litigate over this, that's going to be the first thing that you're going to have to prove. You're going to have to prove that you took every single measure possible to keep them out. So do the paywall, even if it doesn't work. Do a cease and desist letter. Do IP blocking. Anything that you can do to show the court, like, look, they essentially trespassed. They violated the authorization mechanism that I had on my, your blog, your newspaper, whatever. That's going to be your best bet. But you're really going to want to, if you're going to go the legal route, it's an absolute mess. Good luck.
So Cameron, speaking of the legal route, Cameron, as a creator, do you, and as an AI user and a content creator, do you feel like you have the legal clarity you need now as a creator to fully use AI, or is it still, you need more clarity?
I think we're just operating. I mean, it probably depends on the scale and level of the business you're at. From a content creator, especially when you start talking about, I think that some of the people who are most vulnerable on the creator side are like writers, anybody in kind of music, any kind of illustration, video, graphic design. Those are kind of the first wave of content that people are trying to protect. We've already been, how do I say this? As a advertising, content strategy, content creating company, prior to generative AI and using that as an additional tool, there's still so many different protections if we wanted to go out and use copyrighted material and so forth. There was legal clarity there. Like, oh, if I need to use this picture, I need to use this image in a video, or if I need to go quote a work or things of that nature. Full legal clarity there. Now, I just assume, and not just assume, I would say, our lawyer didn't really give us any too huge guardrails. If I go onto this, said, we'll just use ChatGPT or Midjourney or something like that. If I put this information in and ask for something back, I assume what I get back, I can use. I think so that's this legal, the legal clarity we have, I would think, when you start talking about small, medium-sized businesses. Once you start getting into large Fortune 500 and super large multinational corporations, I'm pretty sure they have a very different calculus. But we're now kind of in this weird space where if I put a producer and I say, hey, we need to make this 30-second video or something, there's some animation in it. He goes and uses one of one platform to generative AI to be able to pull from that. That obviously probably used data, and that transform used data that we don't even know where it came from. But now this net new work, now what is our legal? We're under the assumption that that is something we can copyright.
This is a huge deal. I'm so glad you brought this up. Intermediary liability, meaning if you're a third party. So say, and this happened to DeviantArt in one of the OpenAI lawsuits, and nobody talks about it, but it's wild to me. You have a situation where DeviantArt, they basically just did a skin over Stability AI's service. So DeviantArt had their own AI, but they're using Stability. They don't know what's in the training set. They don't know what Stability's, what they're using to train their models. They don't have any insight into that. DeviantArt is just a third party that is offering a chatbot. They got roped into this massive lawsuit with OpenAI, and they literally, I think in one of their pleadings, they said, like, look, we didn't know. We don't know what's in that data set. So imagine, right, if you want to go out and you want to make a GPT that's using someone else's model, now you have to worry about, well, what the hell is going on with that model? And are you going to be third-party liable for that? Imagine what that's going to do to an industry of small creators and small developers, right? That we have not patched in the law.
Right. Okay. You mentioned some of the court cases. They're winding their ways through the courts and are going to have great impact on this issue. But first, let's talk about a precedent, which is Authors Guild versus Google. Right? And this is a case years ago that said that scanning books, and you can elaborate on this if you want, but basically it said that scanning books for a searchable database is deemed fair use. So can similar reasoning be applied to AI training data sets? What's different?
Sure. I think it largely can. I think the principle is very similar. The practice is very similar. In the Google Books case, they were not reproducing entire books. They were scanning them. They were creating an archive and a catalog where people could then find books that they were looking for. It sounds very similar, again, to the input-output dynamic that you have with generative AI. Generative AI, its cases are a bit more challenging because it might depend on the type of technology that they're using. Some GPTs, as Jess was describing, are really creating descriptions of creative works and not replicating them. They're finding patterns and creating models. Others use, you hear about the diffusion models, which create models by recreating the work internally. And so it's closer to a replication and maybe more challenging to defend. But the concept of taking snippets and pointing people towards other content, or taking data and pointing people towards new opportunities or new creativity, I think is very similar between Google Books and some of the cases we see right now in generative AI.
And before we proceed, I should mention that in about 10 minutes, we're going to do audience question and answer. So please start thinking of your questions. All right, so you mentioned other court cases. What insights can we draw from other recent court cases? We have New York Times versus OpenAI. We have Getty Images versus Stability AI. What insights can we draw from these regarding the application of fair use in AI context? And if you're a creator like Cameron, how are you supposed to navigate through these complexities?
Good luck. It's glass half empty, half full. So with the majority of with all of these lawsuits that we've been seeing, the ones that you've mentioned, and there's more, I think there's like 20 something at this point. At first, we were seeing judges just outright dismiss the plaintiffs. The main claim that we've seen across all of these different cases is that because the works are part of the training set, which, by the way, the plaintiffs in most of the cases that haven't actually been able to prove that their works are in the training set, because their works are in the training set, anything that the GPT produces is a derivative of their work. That is an extreme extension of copyright infringement. And so that's sort of one of the patterns that we're seeing. And the court said, look, no, at least the judges weren't buying that. They were like, no, try again. You need to at least show us that either an output is substantially similar to your work, you need to be able to point to a specific piece of your work that's actually in the training set, which to be fair is really hard because these training data, the training sets are proprietary, which you could get access to in discovery. Now what we're seeing, so they repled, most of these plaintiffs repled, they said fine. All right, some of them were able to point to their works in the training set. Nobody's been able to point to a substantially similar output, which is interesting, but they're able to point to their training set. Now the courts are saying, all right, we're going to proceed. And so I say glass half full, glass half empty in that, like, it would have been great to sort of see that, in my opinion, it would have been great to sort of see the shutdown right then and there, because that is such an extreme overextension of copyright, especially when you can't even prove there's a derivative work. But the fact that the courts didn't also just side with the plaintiffs means that they are at least appreciating the complexity of the technology and the legal issues at stake here. So we're going to wait. I think one of the important ones, Thomson Reuters, I think they have a trial coming up this summer. That one's going to be all about scraping databases like Westlaw. So that's going to be one to keep an eye on. But we'll see. We're kind of in limbo right now.
I'll add, we haven't, many of the major cases, the New York Times case against OpenAI and Microsoft, the Stability AI case, we haven't seen the full pleadings from the defendants yet. So we don't know if they're going to make a strong, full-throated fair use defense, which is what we would recommend at Public Knowledge to defend technology and the right to train AI models. But we'll wait and see what they do. We have seen, certainly in these cases, a pattern of going after the biggest targets because there's a perception that they have the most money to then pay back to a creative artist. And because of that, we've seen some contracts start to be created outside of these court cases for access to or tools that feed data into models, not necessarily explicitly for quote unquote use of creative works, but it's interesting to see that larger companies certainly feel like they can survive by setting outside contracts. I worry about what that means for the future of development of technology for a smaller startup.
All right. Well, let's. First of all, I want to go to Cameron with a question, which is: Are you more excited about AI's ability to give you superpowers as a creator, or more concerned about your work being used in a training database without your permission or compensation?
I think,
or both.
I'm way more excited about the possibilities that are there. And like I said, this is like almost having the $6 Million Man, like having bionic arms and things. Because it's really more my team and my staff. Like they're the producers, they're the illustrators, they're the writers. Even when we have to do sound beds for commercials or content, I really fear for the musicians and so forth who are now, when you start talking, and as we mentioned, is that output substantially the same as the input? I think it also depends on who and what type of content you're talking about. What I've seen, like specifically in the music space, and or the voiceover space, is now there are models there. I can use generative AI voices that there's literally, I want this to sound similar to Snoop Dogg. Like I can do that. That to me sounds like it's not his voice exactly, but to the casual listener, it's like, oh, it's kind of, it's meant to spark that thought. Those things scare me in terms of people's actual personal agency, for lack of a better term, that is then going into a model versus content that they created that these large language models and training models are learning from. I think it's the personal of like scan faces, that type of like personal data that is a little bit nerve-wracking.
Real quickly, I just want to be careful about using the right legal tool for the right problem. I'm very concerned about fraud of people's faces, people's voices, impersonation. My face is not a creative work, and that's what copyright was created to protect. My voice is not a creative work. That is what creative works are what copyright is created to protect. And so I want to make sure we're not using copyright law in this fair use debate to protect people's faces, people's voices. We heard a couple panels earlier about the FTC going after fraudulent use of AI, people's grandmas being called up and people replicating or duplicating impersonation of their grandchild saying, "I'm in trouble, give me money." I think that's fraud, but I don't think that's copyright infringement. And so we see Congress looking at ways to look at name, image, likeness, voice to protect people's personal rights, but not their creative work copyrights. So I think there's a distinction.
That's sort of where we have that's exactly it. Sort of where we have a gap. I'm really glad you brought that up. It's publicity rights, right? And so publicity rights, different from copyright, protects everything that you were saying as well. The gap here is that all 50 states have a different publicity rights law. We don't have a federal publicity rights law. Federal publicity rights could be baked into something like a federal privacy law. So if we want to go after, I totally, it scares the hell out of me, the way in which we can just sort of use AI to mimic our voices and impersonate each other. If we're looking for like a policy or legal solution, I think the tool is going to be privacy, publicity rights, and do it at the federal level so we don't have 50 different laws that, smaller developers now have to worry about. Third parties abusing their models and then violating publicity rights in some state.
Right, and also in terms of solutions, how about just like collaborative agreements? Are there ways that content creators and AI developers can collaborate on mutual beneficial agreements that respect copyright while in allowing innovation in AI technologies?
What worries me there is that there is never going to be. How do you get all the creators in on said copyright? The large groups, if you're part of maybe a professional organization or you're at a larger company or things of that nature, to even have access to that. But the beauty about content creation is that any person could tomorrow decide to write the most formative book ever. Like they could paint an amazing picture or things of that nature. Any individual has that ability to produce content. How do they get then folded into that? Especially if it's not something that they publish on a platform that has some terms of service or something of that nature that they kind of get swept up under. The moment I think that's what I'd be scared about is that if you're an individual creator, an individual person who wanted to do something, or maybe you're not even a professional, especially if you're not a professional, but you can still produce a work, and if I create some content, I should still have the same access of protections that a professional in that field has.
Yeah, Evident. I agree. I think that's really challenging. How do you put a dollar amount on that? We just started out by talking about just how much enormous amounts of data. I think it's fractions of a penny. I don't know that that's really, those sorts of licensing agreements are really going to benefit the broad swath of creators. Yes, we know there are folks from major large institutions that are going after other large tech companies and hoping to get, but will it benefit everyone equitably? I don't know that there's enough money to go around for the vast amounts of data that are contributing to every little piece of training a model. So I think it's really challenging to create those sorts of licensing agreements. Can I add one more thing?
Yeah.
There's a concept out there that folks should look into that's still trying to be defined of public AI. And as someone who used to work at the FCC and thinks about the public interest benefits of media, it's something we should try to develop because there is a benefit of all this knowledge being put into these models and being accessible to the public. And can you, instead of thinking about monetary, again, fractions of a penny, monetary compensation for being included in a model, is there a public interest benefit? Is there an investment in public AI, public options, like we have with public media and broadcast radio? Where we say, there should be a benefit that comes from the development of this new technology and should benefit all of society. I think that's much more interesting than the compensation question.
And that is going to be the last word. I truly wish we had like an extra hour. We are out of time. Let's have a big hand for our amazing panelists.